Immigrant visa freeze. The Footnote D, 75-country ban. Explained. The letter never came. A consular interview that had been scheduled for months, that immigration attorneys had prepared for, that families had reorganized their lives around, that applicants had taken days off work to attend, suddenly disappeared from the system. No explanation in the portal, no notice by email, no rescheduling date offered, just silence where a future used to be. This freeze didn't build over years. It happened in a single executive action, a single action that could suspend your immigrant visa indefinitely, a single action that could separate your family across international borders for months or longer, a single action that could unravel years of approved petitions, paid fees, and documented waiting. One missed update here, and a visa you legally qualified for could vanish before you understood what happened. What the administration did crossed a procedural line that immigration law had held for decades. And when that line moved, consulates around the world did not hesitate. They implemented it with precision, with speed, and with no advance warning to applicants already mid-process. Most people in this situation freeze. They assume someone will notify them. They fall straight into the trap of waiting for a system that has already moved without them. But today, you are going to do something different. For months now, there had been signals, not from the State Department directly, not from any formal Federal Register notice, just signals, that the administration was preparing something with unusually broad reach inside the immigration system. The executive orders had been coming in waves. Border policy, asylum restrictions, student visa reviews, enforcement priorities. Each one targeted a specific population or process. But what practitioners were watching for was something different, a mechanism that could affect immigrant visa issuance itself, not just at the border, but at consulates worldwide, covering countries that had no obvious connection to the stated national security justifications. The administration had been aggressive, yes, but also deliberate in how it sequenced those moves. Each action followed a pattern, a legal framework, a justification, almost a predictable architecture. But what triggered concern among immigration attorneys tracking State Department communications this cycle was that the framework suddenly expanded in a direction no one had publicly mapped. Consular officers who communicate through professional networks recognize the indicators. The quiet update buried inside a visa bulletin footnote. The absence of a formal press announcement for a policy affecting millions. The sudden halt to scheduling in specific immigrant visa categories across dozens of countries simultaneously. The abrupt removal of interview slots from NVC-managed queues. And when the State Department moves without a formal announcement, something sweeping has already been implemented. Earlier this period, the State Department embedded what practitioners are now calling Footnote D inside the monthly visa bulletin, a notation that described a suspension of immigrant visa issuance affecting nationals from approximately 75 countries, covering specific immigrant visa categories, including family-based and diversity visa classifications, not seen applied at this scale in the modern era of U.S. immigration processing. These are actions the State Department only takes when signaling something specific. A national security review requiring case-by-case adjudication beyond standard processing. A directive from the executive branch to pause issuance pending policy implementation. Or a coordinated enforcement posture designed to reduce overall immigrant visa numbers within a fiscal year. Observers weren't certain which justification dominated, or whether all three were operating simultaneously under a single legal umbrella. But one thing was clear. The State Department was implementing a freeze, not category by category, not country by country in isolation, but in a coordinated sweep covering nearly a quarter of the world's nations. And when that happens through a footnote rather than a formal proclamation, every applicant in that pipeline needs to understand exactly what it means for their case. The freeze formalized through Footnote D was not an administrative housekeeping measure. It was not symbolic language inside a technical document. It was an operational directive. Immigration attorneys, after emergency client consultations, described the move as sweeping, unprecedented in its quiet implementation, and most critically, self-executing, meaning consulates did not need to wait for further guidance before halting appointments. But a freeze only creates irreversible damage if you don't understand what it is actually targeting and what it is not. The applicants and attorneys who understood the structure did not wait. Their response was among the most rapid mobilizations of legal resources and advocacy coordination seen in the immigration bar in recent years. Let me break this down precisely. What Footnote D actually says, which countries are affected, which visa categories are frozen, and what every applicant needs to do right now. Today, State Department sources and immigration practitioners confirmed that the Footnote D suspension targeted immigrant visa issuance at U.S. consulates globally, affecting nationals of approximately 75 countries, including populations that had active NVC processed cases and recently completed document review for what had been standard visa interview scheduling. The freeze was implemented before applicants could complete their interview cycle. It targeted family-based immigrant visa categories, including immediate relatives of U.S. citizens who are nationals of covered countries. It targeted employment-based immigrant visa applicants whose I-140 had been approved and whose priority dates were current. It targeted diversity visa lottery selectees from covered countries who had completed NVC processing and were awaiting final interview scheduling. This was not a case-by-case hold. It was a categorical suspension. And that is what made the Footnote D notation so critical to identify immediately when the bulletin was released. Let's establish exactly what Footnote D is and where it sits inside the visa bulletin structure, because most people, even experienced immigration applicants, have never had to read a visa bulletin this carefully before. The visa bulletin is published monthly by the State Department. Its primary function is to communicate which priority dates are current for employment-based and family-based immigrant visa categories. Most applicants look at two things: the chart that applies to their country and their preference category. The footnotes at the bottom of the bulletin are where administrative and policy-level changes get embedded. Footnote D, in this context, is the notation through which the State Department communicated the implementation of a visa issuance suspension affecting covered nationals. The legal authority cited traces back to Presidential Proclamation Authority under the Immigration and Nationality Act, specifically sections that authorize the President to suspend or restrict the entry of any class of aliens when their entry is determined to be detrimental to the national interest. That authority has been used before. But the scope of this invocation, 75 countries, multiple immigrant visa categories, implemented through a footnote rather than a separate formal proclamation with a public comment period, is what distinguishes this action from prior exercises of that authority. The list of 75 countries embedded within this policy covers nations across Africa, Asia, the Middle East, Latin America, and Eastern Europe. The stated justifications include inadequate information sharing agreements with the U.S. government, failure to meet documentary security standards, and concerns about the reliability of identity verification systems in those countries. What that means practically is that a national of a covered country, even one with a fully approved immigrant visa petition, a current priority date, completed medical examination, and a scheduled consular interview, may find their case frozen at the final step of a multi-year process. This is the specific cruelty of a categorical freeze. It does not distinguish between a case that was filed last year and a case that has been pending for a decade. It does not account for the fact that a family has already liquidated assets, prepared for relocation, or withdrawn children from schools in anticipation of an imminent move. The freeze applies regardless of individual circumstances. For immediate relatives of U.S. citizens, typically the fastest immigrant visa category, exempt from numerical caps, This freeze is particularly disorienting. Immediate relative visas are not subject to annual limits. There is no quota to exhaust. The only thing standing between an eligible applicant and their visa is the consular interview and approval. For those applicants, Footnote D does not eliminate their eligibility. It suspends the mechanism through which that eligibility can be exercised. They remain qualified. They remain petitioned. They simply cannot complete the process while the suspension is active. This distinction matters enormously when planning your next steps. For diversity visa lottery selectees from covered countries, the stakes are even higher. DV visas are the only immigrant visa category with a hard annual expiration. If your interview cannot be completed by the end of the fiscal year on September 30th, your lottery selection expires. There is no carryover. There is no extension. The visa is gone regardless of the suspension's eventual resolution. This means DV applicants from covered countries are not just paused. They are in a race against a fiscal year deadline that does not pause with them. For employment-based applicants, EB1, EB2, EB3, EB4, EB5, who are processing through a U.S. consulate abroad rather than adjusting status inside the United States, Footnote D creates a consular backlog that will compound existing processing delays when the freeze eventually lifts. There is a critical strategic distinction here that every employment-based applicant needs to understand. If you are inside the United States and eligible to file an I-485 adjustment of status application, you are not subject to consular processing. Adjustment of status goes through USCIS, not through a U.S. consulate abroad. Footnote D does not directly affect USCIS adjudication of pending I-485 applications. If your priority date is current, if USCIS is accepting filings under the applicable chart for your category, and if you are lawfully present in the United States, filing for adjustment of status now, rather than pursuing consular processing, is a concrete way to remove your case from the pipeline that Footnote D is directly freezing. This is not a permanent escape from the policy, but it moves your case to a different track, one that is not currently subject to the consular suspension, and one that provides you with employment authorization and advance parole while you wait for final adjudication. Consult with an immigration attorney about whether adjustment of status is available in your specific situation. Not everyone qualifies. Not every category permits it. But for those who do, the current environment makes exploring that option urgent. For those who cannot adjust status and must process through a U.S. consulate abroad, the immediate practical steps are the following. Document your current case status completely. Screenshot your NVC portal. Download your case number history. Preserve every notice, approval, and communication related to your petition and visa application. If the suspension is litigated and legal challenges are already being organized, documented applicants will be better positioned than those who cannot reconstruct their case timeline. Contact your congressional representative's office. Congressional Constituent Services can make official inquiries to the State Department on behalf of visa applicants. These inquiries do not override policy, but they create a paper trail and sometimes accelerate case visibility when a suspension is eventually lifted or modified. Monitor litigation updates. Multiple immigration advocacy organizations and law firms filed emergency motions challenging the legal authority for this suspension within days of Footnote D's publication. Federal district courts have reviewed similar executive suspensions before. Courts have the authority to issue injunctions that temporarily block or modify implementation. If an injunction is granted, consular processing for covered nationals could resume while the legal challenge proceeds. Do not assume that because your country appears on the list, your case is permanently closed. The history of executive order-based immigration suspensions includes multiple examples of court intervention, policy modification, and eventual resumption of processing. The travel bans of prior administrations were litigated, modified, partially enjoined, and ultimately changed over time. The same dynamic is already in motion around Footnote D. There is one more layer to this that connects the immigrant visa freeze to the broader administrative posture you need to understand as someone navigating this system. The Visa Bulletin is published by the State Department, but its implementation depends on coordination with USCIS, the National Visa Center, and individual consular posts. Each of those entities has its own operational timeline for incorporating policy changes. What that means is that the freeze may not be uniformly implemented across every consulate on the same day. Some consulates suspended appointments immediately. Others continued scheduling briefly before receiving further operational guidance. Some applicants from covered countries received interview notices after Footnote D was published, only to have those notices subsequently canceled. If you received a notice after Footnote D was published, do not assume that notice is valid without confirming with your consulate directly. And if your appointment was canceled, do not rebook through the standard scheduling portal without first understanding whether your country's suspension is still active. The environment is shifting. Checking once is not enough. The people who protect their cases through this period are the people who check the Visa Bulletin on the day it publishes, who read the footnotes, who verify their consulate's current scheduling status, and who have legal representation that is tracking these changes in real time. As this fiscal year continues, more clarity will emerge about which countries may be removed from the Footnote D list through diplomatic negotiation and which suspensions will be extended or expanded. But one thing is already clear. Understanding what Footnote D is, knowing whether your country is on the list, knowing the difference between consular processing and adjustment of status, none of that makes you a threat to anyone. It makes you a prepared applicant. It means you are not caught off guard when a visa bulletin changes the rules mid-process. It means you are protecting your family's future with accurate information instead of rumors and panic. Share this video with anyone you know who has a pending immigrant visa case, family-based, employment-based, or diversity visa. It might save their case from slipping through a deadline they didn't know existed. Subscribe to Visa Status Radar for more protection. We protect you with real information as the next phase of this freeze unfolds.